webinar from the section of Civil Rights and Social Justice. During the 2017-18 bar year, our goal is to rapidly respond to government action that may impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from our subject matter experts. We encourage you to check the section website, www.americanbar.org/CRSJ, for more great programming. If you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop so that we can offer them to our members and the general public. Today's program, entitled Civil Rights Protection for Discrimination, Recent Developments in the HHS Office of Civil Rights, is an in-depth discussion among experts of the new division of the HHS Office focused on the rights of healthcare providers to determine or deny care depending on the provider's religious conviction and the proposed rule. We're thrilled with that our panelists have joined us today, and you even can ask them questions during the program by checking out the drop-down box on your right-hand side that says questions and sending them in. Our moderator today is Kira Shepard, who is the director of the Racial Justice Program at the Public Rights Private Conscience Project at the Center for Gender and Sexuality Law at Columbia Law School, where she examines the impact that religious exemptions law have on communities of color. Before joining Columbus Law School, she was the executive director and director of campaigns at the Black Institute, an action think tank that leads advocacy work in the areas of racial justice, immigration, education, and economic justice. Welcome to all of our panels, and welcome, Kira.
Thanks, Paul. Thank you for that introduction. And I would like to thank you all for joining us today for today's webinar, Civil Rights Protections for Discrimination. Sorry. My name is Kira Shepard, and I am the Director of Racial Justice for the Public Rights Private Conscience Project. The Public Rights Private Conscience Project is a think tank that examines the multiple ways that religious liberty rights undermines other fundamental rights to equality and liberty. As many of you might know, the Trump administration has been increasingly using religious liberty laws as an excuse to push forth laws that protect a very conservative, narrow view of sex, reproduction, and marriage. Just last May, he issued executive order promoting free speech and religious liberty. Following that, in October of 2017, his administration rolled back the birth control mandate, virtually making it acceptable for any employer or health insurance provider to deny their employees contraceptive coverage based on their religious or moral beliefs. And then right after that, Sessions from the Department of Justice issued guidance on religious liberty protections, basically instructing all federal agencies to give leeway to staff, contractors, grantees who wish to use religious exemptions to be excused from federal law, rules, and regulations. So we see this ramping up with these religious liberty protections from the federal government. And then most recently, what we're going to be talking about today is a recent rule that has been proposed from the Department of Health and Human Services that basically assists healthcare providers who wish to be excused from providing abortions, reproductive health care, and other care based on their religious or moral beliefs. And why the way the rule is written looks like it's only allow healthcare providers to refuse abortion and reproductive health care services, the rule can be easily expanded to allow providers to refuse services to those in the LGBTQ community. And the law itself is pretty broad in its scope, and it applies to a number of different healthcare entities, over near 800,000 hospitals, dental offices, ambulance service providers, the list goes on and on. And in addition to the rule, the Department of Health and Human Services Office of Civil Rights opened a new division that would allow it to give protections to healthcare providers who wish to deny services based on their religious beliefs. So today, our webinar is very timely and important, and we're going to cover a lot of ground. So I'm very excited to introduce our panelists. First, we have Susan Burke-Fogel, who is the Director of Reproductive Health for the National Health Law Program. Here, she is a national expert on reproductive health law, focusing on Medicaid, the Affordable Care Act, and other low-income health programs, and how they can support access to reproductive health services. She works to break down silos and maintain reproductive health and mainstream reproductive health into low-income health advocacy agendas. Fogel is the author of many amicus brief papers, articles, including the National Health Law Program's groundbreaking report, Healthcare Refusals, Undermining Quality Care for Women. Thanks for being here with us today, Susan. We also have Jamil Fields, who is a Senior Policy Analyst at Planned Parenthood Federation, located in Washington, D.C., where she works to improve reproductive health care access for low-income people, women, and young people across the country. Jamil's portfolio focuses on healthcare access, including healthcare reform and religious refusals. Thanks for being here, Jamil. And we also have Jennifer Pizer. Jennifer is a Senior Counsel of Law and Policy at Lambda Legal. She is a national leader in policy development to end discrimination against lesbian, gay, bisexual, and transgender people and their families, working closely with government officials and community leaders and academic experts. She specializes in addressing the problems created by so-called religious freedom demands that seek to legitimize discrimination. So I want to thank all of our panelists for being here today. And we're going to start with Susan, who's really going to unpack this new rule and division for us.
Okay, thank you very much. I'm sorry, I'm having a technical difficulty here. So I want to start just with telling you a little bit about the National Health Law Program and the work that we do. NHELP is a national nonprofit law firm committed to improving healthcare access and quality for underserved populations. We work to ensure that every person has access to quality, comprehensive healthcare with dignity. And I'm sorry, but I feel like I've lost this. So I'll just keep talking while I figure out how to bring my slides back up. Let's just talk about what healthcare refusals are. Healthcare refusals really are, they're also called religious exemptions, conscience clauses, really are the ability of people in a healthcare system to opt out of providing the basic standard of care. Every person who enters a healthcare system expects that the care that they receive is going to meet the standard, the basic standard of care. That'll be evidence-based, patient-centered, and prevention-oriented. Usually in the law and medicine, there are serious consequences for failing to provide the standard of care. And so we think of healthcare refusals basically as an opt-out, a get-out-of-jail-free card, if you will, to opt out of meeting those standards with impunity. All right, I'll just go on. Refusals are generally fall into two different areas. They're ability to refuse to provide care for other people, to opt out of, as I said, meeting those standards of care. And then there's refusals to meet requirements for one's own health care or for parents to meet the health care of their children. Things like vaccinations, minimal essential coverage in the ACA, as well as some kinds of health screens for children. We are not going to talk about that today. We're really going to talk about the laws and rules that allow individuals and institutions to opt out of providing services to others. All of the statutes underlying the new rule are based on when there is certain federal funds involved. And they all use the language of discrimination, which I know that Jamil is going to talk about a little bit later. But the rules are really interested in elevating the concept of protecting people who refuse to provide care to other civil rights laws that protect against race discrimination, discrimination against immigrants, against LGBT people. Okay, so slides will be here in a minute. So I'm going to start with the Church Amendment. The Church Amendment is named after Senator Frank Church, and not the religious institution. And the Church Amendment was enacted not long after Roe v. Wade, and it has different elements that both protect individuals who are willing to provide services as well as individuals who refuse. And I will say of the underlying statutes, this is actually the only one that affirmatively protects willing providers. So the Church Amendment says, first of all, that as a condition of public funding, that an individual cannot be required to perform or assist in abortions or sterilization, that an institution cannot be required, there's my get out of jail free card. Okay, here we are at the Church Amendment. Thank you, Paula. That an individual, an institution cannot be required to make its facilities available for performance of an abortion or institution. An institution can't be required to provide personnel for abortion and sterilization, and an entity or biomedical research cannot discriminate against individuals in employment for either refusal or willingness to perform an abortion or sterilization. And then there's a little bit of a catch-all that an individual cannot be required to perform or assist in other parts of health services to which they have a moral or religious objection. I want to flag that I have put things in red because this is the language in the underlying statute, and we'll see how that language then gets, frankly, distorted away from what we, dictionary definitions in the rule. Next slide. The Weldon Amendment. The Weldon Amendment is an appropriations rider. It gets enacted with every appropriations of every year or other year. And it's specific about abortion. And it says that government, again, cannot discriminate about provide, pay for, provide coverage of, refer for abortions. And it talks about a healthcare entity. And this definition is really important, because this definition, frankly, is common sense. A physician, a healthcare professional, a hospital, an HMO that provides insurance, all tied very closely to healthcare, because this is about healthcare. And the Affordable Care Act has a similar provision that says a health plan in the marketplace cannot discriminate if a provider facility doesn't provide abortions. Again, specifically about abortion. Next slide. The Coase Amendment is also one of the underlying statutes, and this is about medical training, and basically is based on whether an institution can be denied accreditation or licensing because it refused to provide, teach, or refer for abortion. And this is really important because it underscores that abortion is basic health service. Abortion is healthcare. It's normal healthcare. And it is only because of these exclusions that institutions are allowed not to teach or provide healthcare, because otherwise they would be required to under standards of accreditation. Next slide, thank you. So, the rule. So, we're now going to talk about the rule, and basically the rule is about who can refuse to do what. Next slide. So, remembering the underlying statutes are all about healthcare professionals. The rule, unfortunately, kind of blows that up. So, first of all, it adds a definition of an individual, which is a person under 1 U.S.C. 1, which is a very, very broad definition of person that includes corporations, companies, the state, public agencies, pretty much everybody. The rule specifically adds a plan sponsor. Remember, both Weldon and Church talk about health plans, but this rule now adds what would help a plan sponsor who is not engaged in healthcare, basically, which would be an employer. And that harks back to Hobby Lobby, suggesting that even an employer can refuse to cover abortion, even though they are not at all healthcare providers. And they also define the workforce, again, as pretty much everybody in the healthcare system, using examples of volunteers, trainees, even the agents of a covered entity. You can remember that in 2016, there was an Office for Civil Rights complaint filed when some employers did not want to cover abortion in the healthcare plans, and the Office for Civil Rights came to the conclusion that they were not covered by the Weldon Amendment because they were not healthcare entities. Well, these rules want to change that. And this whole question of workforce raises some really important questions. What does it mean to be part of the workforce? Is this a candy striper delivering snacks? Is this an admitting clerk? So I think we have a lot of concern about this very, very broad definition. So what can they refuse to do? Again, remember the statutes are about delivering healthcare services or assisting in the performance of a healthcare service. Now, if we look up in the Merriam-Webster definition of what does it mean to assist, it means to help, usually by doing a share of the work. And they give the example of surgery, where one surgeon comes in to help another surgeon in a surgery procedure. And I think that we might not agree with the rules, but we might be able to agree that that feels like assisting in the performance. You're actually hands-on performing a service to which a person might have an objection. However, these rules say articulable connection. Now, many of us in this webinar are lawyers, and I think we can probably articulate anything. So the idea to have this very, very broad and confusing definition of what does it mean to have an articulable connection. For example, if a person is hospitalized for transition-related services, a transgender person, one could unfortunately argue that every service they get is articulately connected to why they're in the hospital. So we believe that this goes way, way beyond the statute. And it gives some examples. Also, there's no longer requiring a moral or religious objection. The rule quite explicitly just uses this kind of, I choose not to do it, I'd rather not. The idea that anyone could just decide, perhaps based on the service, perhaps based on who the person is, that they don't want to participate in the service. And the last thing that's really important is the question of referral. We would think in a healthcare delivery system, a referral, my primary care physician thinks I need an MRI, they give me a referral, they tell me what I need, they tell me where to go, they give me information that's really connected to me getting the service. Instead, the rules use very broad language about providing information by any means, and not only directly for a service, but if a service is as they use this language, a possible outcome. So what does that mean? Can I refuse to do an ultrasound for you if I think maybe you might use this information to get an abortion? We don't know the answer to this, but this is why these rules are so incredibly confusing and vague. Next slide. So, enforcement. As Sarah mentioned, has a lot of new powers. And so I just want to end with the requirements that we've never seen before. All the healthcare entities, the hundreds of thousands of entities that Kira mentioned, all have to post in a visible location in large type a sign that talks about the rules and gives a phone number or a contact for the Office for Civil Rights. On their website, has to be on their website, and OCR is going to conduct compliance reviews, and entities will get more favorable reviews the more places that they post these signs. And I'm going to skip the next slide, because I think Kira's already spoken about this. And the next slide is just to say thank you very much.
Great. So I'm going to take us to now talk some about some of the implications we think that this rule could have on women's access to care. My name is Jamil Fields. I am a senior policy analyst at Planned Parenthood Federation of America. Many of you might be familiar with Planned Parenthood, but Planned Parenthood is the largest women's health provider in the country, operating over 600 health centers around the country. And so we have a particular interest in how this rule impacts not only women, but LGBTQ people and a range, and anyone else who seeks to access health care. And so I'll focus my remarks on women, and I know Jenny and Kira will talk a little bit further about the impact. So I'll divide my short remarks up into two buckets. One, talk a little bit, build upon what Susan mentioned about the impact on the services, that might be impacted under this proposed rule if it were to become law, and then talk about the potential implications on the delivery of care. So first, to speak to the services impacted. So we know, as Susan mentioned, the rules is just specifically mentioned that it's abortion services and broadens the ability and the grounds, the individual, and the ability to deny access to abortion. And we know that's particularly problematic because if you have the right to have an abortion means nothing if you don't have actual access to have said service. Up on your screen is a snapshot taken from a recent study that was published in the Lancet journal, and it found that women already have barriers to accessing abortion, including around the average woman of reproductive age has to travel between 10 to 79 miles to access an abortion, and that's but varies, as you can see from the map, significantly based off of your geographic location. In particular, you'll see that some places in the Midwest, women have to travel as much as 100 up to almost 180 miles to access an abortion, and we think this rule would add existing barriers for the reasons Susan mentioned. So I know some of my esteemed co-panelists will give some stories, and I'll just start with one. I think it really sort of illustrates. First, as Susan mentioned, there are already existing refusal laws that allow institutions and providers to deny access to care, and we think this will add more barriers on top of that. And this is one such story taken from a blog published in the Salon magazine in 2011 from a woman who described how she presented at a hospital, and even though everyone knew that a pregnancy wasn't viable, the doctor refused to provide an abortion, even though it was necessary for her health, and also because could have threatened her future fertility. She did eventually was able to get the abortion after several excruciating hours that she describes in this piece. And, this is one such woman, and I could probably pull stories from lots of other women who might have been in similar circumstances. I will note that as horrifying as this is, every person, no matter their circumstances, whether it's in this sort of emergency situation or not, that wants to have an abortion should be able to access that. But speaking of emergency services, one thing that is particularly concerning about this rule is that it is silent upon whether it prohibits governmental entities from taking adverse actions against a healthcare provider that refuse to perform or assist in the performance of an objective to service when it's necessary to save a life. So would a state be able to take action against sort of this provider that refused to provide care in this emergency situation? This is not consistent and with EMTALA, and which, as you know, the long-standing federal law that requires Medicare receiving hospitals, so virtually any hospital, to either treat, stabilize, or perform an examination for a person who presents in the emergency room. And so this rule it's unclear on how EMTALA could be enforced under this rule. This also is not consistent with most other laws that have restrictions around abortion. Also have, I should say, some exception for an emergency situation or life of the woman, and we don't see that here. Another explicitly named service in the rule that would be impacted is that of sterilization. Before I continue, I think I would be remiss without acknowledging that this country has had a problematic history around forced sterilization. However, we do know that voluntary sterilization is an important family planning method for when it is the woman's choice and it is voluntarily chosen to happen. In particular, postpartum sterilization is a particularly time-sensitive procedure that can be is most impacted and access most undermined if if it's not performed, shortly after giving birth. And up on your screen is a quote from the American College of Obstetricians and Gynecologists, who uplift the importance of having access to postpartum sterilization, and the ability to refuse to provide a sterilization under this rule impacts that. There's also already existing barriers to accessing sterilization. In particular, 18 states allow individual healthcare providers and institutions to refuse to provide sterilization, and this rule only compounds that ability to refuse. Then, as Susan mentioned, there's a lot of very troubling open questions about what this means for other reproductive health services and other health services generally. As Susan mentioned in our opening remarks, there's a very broad definition of discrimination, and there's also a broad definition of what it means to assist in the performance of. So, if I object to providing an abortion, does that mean that I don't have to schedule an appointment or clean the utensils if I know or think that doing so might lead to accessing those services? Also, as Susan mentioned, the very broad interpretation around the Church Amendment that's found in this rule expands the scope around being able to refuse care for, it mentions any healthcare program or activity, and so it's unclear what that means. Does that mean that they could, someone could refuse to provide any number of these services listed on your screen? Filling a prescription for birth control, transition-related services, which I'm sure Jenny will talk more about. And so it's it's an open question, but even that open question is problematic. The rule on the same theme, it does explicitly outline a number of services where the department is concerned or seeking to protect healthcare workers from being including the last one that I'll note there listed is about administering or receiving certain vaccinations that might have been derived from fetal tissues that were taken after an abortion. And so, how I think the rule itself just gives an example that the rule itself intends to be very wide encompassing. So switching gears some to talk a little bit about the impact on the delivery of care. So again, Susan posed this question about who can refuse. The proposed rule would expand the ability, we think, of healthcare institutions to be able to object to a service, even when there is a willing provider to provide that service. There's also, broad definitions giving around who is an individual, who is a part of the workforce, volunteers, trainees, and would said person, if you volunteer to work somewhere, should you be able to refuse to do an activity that would that you think might lead to an objected to service, and what does that do, and how does that impact the patient-provider relationship is particularly concerning. And so, again, a couple more examples that I'll uplift of how this has played out in the past. For instance, there's one of the stories on your screen details an example of a woman who presented at a hospital, and her physician wanted to perform an abortion when she was having a miscarriage, but because it was against the hospital's religious directives, he literally felt like his hands were tied, and noted that the woman was dying right before his eyes. In another instance, a similar case where a doctor, spent his own money to transport a woman who needed an abortion to the nearest abortion provider, spent money on a taxi while the woman was already in a very fragile state. So, there's again, posing some questions here about what this means for the willing provider to provide the full range of reproductive health care. Also, because of some very broad interpretations around the rule, it's unclear on who also must comply with these onerous requirements. So, for instance, will a health center that primarily provides abortions, such as like a Planned Parenthood, be compelled to hire medical staff that refuse to perform or assist in the performance of an abortion? Similar, will a health clinic that's funded for STI treatments and contraceptives be required to hire staff that refuses to provide certain services? The potential. Even these questions, again, is concerning, given the importance of providers being able to make decisions around in collaboration with their patients around healthcare decisions. And so I'll note a couple programs that are particularly impacted or could particularly be impacted, including the Title X program, which is the only domestic family planning program. This rule seems aimed at allowing these funds to go to entities that refuse to provide the full range of counseling options, including counseling on or referral for abortion, even if it's requested. And as Susan mentioned, that definition of referral is very broad. And in fact, the rule even contemplates, handing out a pamphlet that might have boilerplate language about where one might be able to access service, and allowing, someone to object to even that. And similarly allowing those funds to go to a entity that refuses to provide the broad range of family planning services, which goes against the purpose and integrity of the Title X program. Last thing I'll mention is that the impact is not just domestic. There's an impact on global health programs, including the President's Emergency Plan for AIDS Relief. PEPFAR, as is known, that provides antiretrovirals, HIV medication around the globe. The rule reiterates existing refusals, but also applies some of the domestic restrictions in the global context, and seeks to allow some individuals to be able to refuse to provide almost any service or research activity in the global context. And I'll go quickly on this slide that, the burden on providers or health centers or entities that must comply, including state and local government, is detailed in the rule as costing over $300 million in the first year alone, and the benefits are not shown to add up to that cost. As Kara mentioned, this is a broader part of a larger scheme of policies we've seen recently that impact women's health. I won't go through these, but it's just worth keeping in mind that this rule, unfortunately, does not live alone in its potential impact. Thank you.
Great, thanks, Jamil. So I'm going to talk a little bit about how healthcare refusals impact women of color. My think tank in January came out with a report called Bearing Face: The Limits of Catholic Healthcare for Women of Color, that looked at the way that the expansion of Catholic healthcare have had a disproportionate effect on the sexual and reproductive healthcare available to women of color in many communities across the nation. For those of you who don't know, Catholic hospitals follow a set of religious directives called ethical and religious directives, and they prevent healthcare providers that work at Catholic hospitals from providing a number of services, from contraceptive care to abortions, treatment for certain types of ectopic pregnancy, fertilizations, tubal ligations, tying tubes, women have their tube ties, sterilization, similar to some of the refusals that Jamil mentioned in her presentation. One story that I like to, we heard some stories earlier, I like to give this particular story when I talk about how refusals, how the ethical religious directives can potentially harm women. This is a case of a woman named Tamisha Means. When Tamisha Means was 18 weeks pregnant, she went to the nearest hospital in her community in Michigan. It was a Catholic hospital. She didn't realize that. She was in a lot of pain. The doctors examined her and realized that the fetus was no longer viable, that her health was in jeopardy. They knew that the best medical standard of care at that time would have been to evacuate the uterus, but because they followed these directives, they just sent her home with a pain reliever. They didn't tell her that it was because of the directives, and she didn't know they followed these directives. She came back to the hospital the next day in excruciating pain. She was bleeding. They sent her home again. She came back a third time, and then they provided her with some care because she was miscarrying at that point, and they could no longer detect a fetal heartbeat. So this is a good, her story is a good example about how these refusals can harm women. She was somewhat fortunate where someone who worked at the hospital told her to go to the ACLU with her case, and she did. Unfortunately, she lost. The court, it was a malpractice suit, and the court said she didn't have a present physical injury. But through the work that I've been doing around reproductive justice and through the conversations that I've had with people, it seems like the situation that she went through happens more often than we actually know or would like to think or hear about. I was talking to a reproductive justice advocate, friend of mine, who told me a similar situation happened to her. Her stories in the report, Lori Bertram Roberts, she went to a Catholic hospital in her neighborhood, and she was in a lot of pain. They turned her away twice because she was uninsured. She was, at the time, 18, uninsured. So she didn't want to go back to the hospital the third time after she was refused care. So she ended up hemorrhaging in her bathroom, just bleeding, her family had to call the ambulance. And then by the time she went to the hospital, they gave her care because they could no longer detect a fetal heartbeat. So these refusals could potentially have really lasting traumatic effects on women. One thing that we focus on in the report is how these refusals kind of exacerbate and compound existing healthcare and racial disparities that women of color already face. Recently, ProPublica and NPR did an investigation looking at maternal mortality in the United States. And if you haven't read those articles, then you really should. They're really important work. And what they found is that healthcare disparities facing women of color, particularly Black women, are particularly dire at this time. Black women are 3 times more likely than white women to die during pregnancy. So as we were putting this report together, we found it really important to examine how these disparities impact women of color. Women of color right now are having trouble accessing health care, and they're having pregnancy complications at rates much higher than white women. So at this time, it seems particularly unjust to expose them to refusal laws that limits their care even further. And we look at a number of different health care disparities and racial disparities facing women of color. And I'll quickly go through those and talk about how refusal laws can actually compound and exacerbate these disparities. So Black and Latina women are more likely to be uninsured than white women. And if you're not insured, if you don't have health care coverage and you don't get the type of care you need, it's very likely that you won't get prenatal care. And if you don't get the care you need, then that's why Black and Latina women have higher rates of pregnancy complications because it's more likely you're going to have one of the reasons, it's more likely you're going to have a pregnancy complication. And if you have a complication, such as the complication that Tamisha Means had, where the best medical standard of practice will call for the provider to evacuate your uterus, you won't get that care and you'll be refused that care under these new rules if they go forth. In addition, women of color are more likely to have unintended pregnancy. This is the reason that a number of women of color, more women of color than white women, have their tube tied. And as Jamil discussed, the best, safest, cheapest way to have your tube tied is right after you actually give birth. But under certain, under refusals, under the Catholic Hospital's ethical and religious directives, a healthcare provider does not have to do the tubal ligation. And this could potentially impact all women, but particularly women of color, and this could particularly cause unintended pregnancy rates to increase even further. A recent report actually looked at how different refusals across the nation impacted care, and they found that since the expansion of Catholic hospitals and the ethical religious directives, the number of tubal ligations has gone down by 30%. So, you know, if this rule goes forward, then we're going to be seeing more refusals in this area, and this is going to harm women of color. Another thing we talk about in our report is racial biases and how that contribute to women of color not receiving adequate care and receiving substandard care. Implicit bias comes into play. Racism comes into play. Stress actually causes pregnancy complications. And one thing we talk about in our report is there was a number of studies that show that healthcare providers have biases, racial biases regarding, they actually believe that Black people can actually withstand more pain than white people. So because of that, they undertreat Black people for pain relative to white people. Whenever I think about that, I think about the discrimination that's allowed under these refusals, the ethical religious directives. I think about the Tamisha Means story and how she was in immense pain. One person who worked at a hospital with her, and one woman who told her to go to see someone at the ACLU, said that she was in more pain than someone who was actually in child delivery, giving birth. It was because she was facing an infection. So she was in immense pain, and she goes to these doctors and they refuse her care and they just give her a pain reliever. So all of these health and racial disparities can really be compounded with these refusals. So that's why I think the racial justice community, as well as the reproductive justice community, as well as the LGBTQ rights community, should be really concerned about these new rules. And I'm going to end it there.
Okay. So, not sure if my slides have come up.
Yes.
Yes? Okay, great. Hi everybody, I'm Jenny Pizer. I'm with Lambda Legal Defense and Education Fund, Lambda Legal, as we say. For folks who don't know us, and I hope most of you do, we're a legal nonprofit that does impact litigation, policy advocacy, and community education to protect and advance the civil rights of lesbian, gay, bisexual, and transgender people and everyone living with HIV. I'm delighted to participate in this and want to do a particular shout to the wonderful folks at Planned Parenthood. The reality for LGBT people and people living with HIV today, you know, without this new rule and this new division within HHS is a picture of health disparities and inadequate access and discrimination within healthcare services that affect our communities. And Planned Parenthood has been among the providers who have been welcoming and culturally competent and really wonderful for members of our communities, something that's much appreciated. LGBT people are everywhere within every community. So, you know, what you've just been hearing about in terms of health disparities and barriers to quality care affecting women of color, affecting our communities. Well, you know, there's queer people in all communities, and an important part of the challenges we face is compounding levels of discrimination and barriers to access, barriers that are also made worse by poverty, by geography, by so many other things, limited insurance, lack of insurance. So we had been working hard, focusing on improving the situation, and the Affordable Care Act, Section 1557, which folks may be familiar with, is the non-discrimination section that bars discrimination based on sex by programs and services receiving federal funding. And as was said, that's many providers, most hospitals, and many providers across the country. And so, and that protection against sex discrimination in health programs and services, properly understood, protects against discrimination based on sexual orientation and or gender identity, because there's no way to understand those concepts that isn't based on sex. And the courts have been understanding that. We've had the beginnings of good case law there, paralleling the development of the law in the employment field under Title VII, and in the education field under Title IX and the Fair Housing Act. All these federal statutes that bar sex discrimination, properly understood, protect LGBT people. So we were making progress, and the previous administration, in issuing the 1557 guidelines and various other things, were helping to provide clarity and understanding about the law, and that was providing some important protection. And I will say, in particular, for transgender folks who need access to appropriate medical care, including gender confirmation care. The new division, this proposed new rule, the focus of the current administration on elevating religious rights, religious refusal interests and concerns, generally over the interests of patients, the needs of patients, and the work of providers who want to provide appropriate care, you know, it's immensely concerning, and it represents a potentially devastating setback as we're dealing with an already troubling situation. We should acknowledge that the use of religion to justify discrimination against LGBT people or people living with HIV in healthcare services is nothing new. This is something we've been dealing with for quite a while, unfortunately. And there is case law, there's been advocacy in legislatures to address this problem. But the situation we're looking at now is likely to be a significant worsening of an already problematic situation. You know, part of the situation is that, as has been mentioned, the existing rules that specify particular exemptions or conscience rights with respect to abortion services and sterilization have been invoked in other contexts to justify other refusals of care that go way beyond what those statutes provide. This is something we've dealt with in the past. It's problematic. Some of that is based on misunderstanding and good faith belief that the statutes are broader than they are. But some of it is people thinking that those exemptions should exist and overreading the statute. So again, this is a situation that we're concerned is going to worsen significantly. And if and when this kind of thing does happen, it will be, and Susan addressed this at some length, contrary to appropriate medical ethics that forbid discrimination and require addressing patient health needs according to standards of care. Certainly the non-discrimination laws of a number of states, less than half the states, but a good number of states do have non-discrimination laws that apply here, and proper understanding both of Section 1557 of the Affordable Care Act and also of Title VII. So because Title VII provides a requirement that employers provide reasonable accommodation, an appropriate accommodation to the religious concerns of workers, but not if it imposes an undue burden on the employer. There's lots of case law about this that has worked out an appropriate framework for considering religious interests of workers. And this proposal goes much further and creates a conflict between the explicit statutory protections that are there for employers to not be required, for example, to hire people for jobs where they're going to object for religious reasons to doing an important part of the work. So there's a number of areas that we're particularly concerned about on behalf of patients because of what we have been seeing already, areas where we're concerned that things will get worse. And I want to stress that we think it's likely to get worse, not because the new rule provides a right to make it worse, but because there's misunderstanding, there's overreading of the statutes, because the regulation, as Susan explained, is vague, it's overbroad, it sets up a situation that appears clearly designed to elevate religious rights over other needs. And it has this very aggressive enforcement mechanism built in that, again, seems very clearly designed to have a chilling effect for healthcare providers, for employers, institutions that want to provide good care and don't want to have inappropriate, unjustified religious objections interfering with the healthcare that they want to provide to their patients. So as I identify these areas, I am not saying that all these kind of refusals are now proper. They are not, but they're things we're very concerned will happen anyway. So one of the main areas of concern is transition-related healthcare for transgender folks. One of the examples in the proposed rule cites a California case where a Catholic hospital interfered with the provision of a hysterectomy to a transgender man, where that procedure would have been done really without question for somebody who needed that care, say, for fibroids or cancer or some other kind of health need. The religious rule imposed by that institution was that, well, if that same procedure was related to gender transition, then it was forbidden. Well, gender transition for some individuals is the medically necessary care. Sometimes it involves surgery, sometimes it involves hormones, sometimes it involves counseling. There's a range of things that the individual patient, that may be appropriate for an individual patient. It's of immense concern that this rule provides some support, and we would say legally inappropriate support, for the idea that any objection to any of this care could be refused based on the idea that statutes that have to do with sterilization procedures could be understood as a reason to block transition-related care. And that's based on a religious idea held by some that gender transition-related care, by definition, is sterilization. That's not true as a medical matter, and it wouldn't apply to some of these procedures if needed for a different reason. So we see that as discrimination and potentially a devastating situation for patients. And we are concerned, and this was noted before, that some providers, some employees may themselves refuse to provide services or work or tasks related to the medical care needed by a transgender patient, whatever the care may be, whatever the task may be, based on an extremely attenuated and inappropriate extrapolation from the idea that anything a transgender patient might need could be put under a banner of sterilization. There are other religious refusals that patients have encountered over the years, including a range of things related to HIV, education, preventment, and treatment. recognition of same-sex relationships for purposes of visitation, decision-making, or employment benefits for workers, for employees. In the mental health treatment and counseling area, likewise, there have been objections to respecting and providing counseling to somebody in a same-sex relationship, whether the mental health need related to that relationship or not. Likewise, infertility care, prenatal care, labor and delivery, pediatric care for a patient who is in a same-sex relationship. And then we haven't mentioned this, but end-of-life care is something that is specifically called out in the proposed rule, where there are religious objections that already interfere with patient wishes sometimes, and that may threaten to get worse. With respect to providers who want to provide medically appropriate care, and care in particular for particular populations, some of the providers that particularly serve the LGBT community, we're concerned that they're going to encounter difficulty meeting patient needs according to the standards of care, the way they do now, by being forced to hire or being unable to provide employment directions to their staff to ensure that patients are treated with respect and get the care that they need. This could make it very expensive or even impossible for the institutions to provide appropriate care if they're not able to hire the people who want to do the work in an appropriate manner. Again, I want to stress the law is not going to properly stood, should not allow this to happen. But we are worried about the chilling effect, confusion. The rule is so vague, there's not appropriate due process protections for the institutions that want to provide the care, and for individuals who want to provide the care. So we're very concerned that people are not going to get what they need. Lambda Legal we've published some analyses of these problems as they have been developing. As was explained earlier, these proposals come following a number of other problems that already are hugely problematic. Among the top priorities for Lambda Legal and some of our sibling groups working in this field is helping our communities understand what these proposals might do, what they should not be understood to do, and to encourage people to speak out, to get in touch with us if they're having problems accessing care. We have legal help desks in each of our 6 offices across the country, and we are standing by, anticipating, unfortunately, that we're going to be hearing from people that are having problems. And when I say people, I mean both individual patients or family members and providers, both individual providers and institutional providers that are having difficulty doing their jobs and meeting the needs of patients. People do have rights. The institutions do have rights. We think these proposals create legal confusion and a chilling effect and likely harm, and we are looking for the opportunities to protect people from that, because it's already, as I said, there's lots of serious problems. We have set up a portal on our website to make it easy for people who are having problems to get in touch with us online. If we don't hear about the problems, it makes it harder for us to intervene. Another goal that we and some of our sibling organizations are engaged in is encouraging people to submit their own comments to HHS through the notice and comment process. The deadline for doing so is March 27th, and we think it may be quite helpful if professional organizations, if medical providers, individuals, and anyone else who has reason to be concerned about this express that to the agency. The agency may or may not be surprised to hear from lots of people, but we're having organized efforts to try to get the word out. An important part of the work that we do is trying to make visible to a lot more people the way this discrimination happens, the types of care that are being denied, so more people can understand the fundamental mistake here of elevating religious concerns over health concerns in healthcare services. And specifically, we're talking here about healthcare services funded by all of our tax dollars for the general public. We have healthcare, as was said earlier, provided to an increasing and in many ways alarming extent by Catholic affiliated and other religiously affiliated institutions who insist for their religious reasons on putting religion first in some of these circumstances. Patients need to come first, according to their medical need and medical standards. This already was a big problem, but these proposals of the Trump administration are threatening to make it much, much worse. So comments submitted by experts and efforts to elevate these concerns publicly through a range of educational methods is really important at this point. We will be providing, and again, some of the other LGBT advocacy groups will be providing information, social media materials, and other encouragement to spread the word about this. And you know, we're talking about a range of ways to spread the word within the communities where we, you know, live and work, and encourage other people to do so as well. Bottom line here is that, you know, LGBT people are within all communities, and for many of our community members, there are multiple layers, overlapping, intersecting types of discrimination or barriers to care that exist. The result is really disturbing health disparities, and we want to do everything that we can working together to reduce that problem rather than seeing it exacerbated. So thank you very much.
Great. Thanks, Jennifer. I think now we're going to dive into our question and answer period. And my first question is actually going to be for Jamil. Can you tell us, it seems like listening to all of this, my obvious question is, why can't someone just go to a different provider who will give them the care they need? Can you explain why that might be a problem?
Sure. So first, I think it's important to note that, you know, all of us as patients have a right to think that when we go to a provider that we will get care and that we will receive the care that we seek, that we think we want, or that we need. And I think that's particularly illuminating as sort of we talked about in these emergency situations where it's not that simple where to just go to another provider down the street, because sometimes the you know, there's a situation that can't be delayed. But even in those non-emergency situations, I think we've sort of talked through here about there's already existing barriers to care that just prevent us from freewheeling going wherever we like. So I think, you know, you, Kira, highlighted many for women of color experience, not only because of the disproportionate amount of existing refusals in Catholic and religiously affiliated institutions in their communities, but also just already outside of this context, women of color experience barriers to care and are least likely to regularly have access to a provider or care. The LGBTQ difficult to find, as Jenny mentioned, a culturally competent health center that will meet one's needs and treat a person with respect. And so, you know, again, it's not so simple to just go somewhere else. And then there is, of course, just a practical matter for those who live in like rural communities where the next place is, you know, many miles away. I'm from Missouri, and I'll tell you, there are certain parts that are very spacious, and it's just not so simple. And then, you know, there is something we all, I think, are familiar with, which is this concept of, you know, our managed care. And we have your insurance plan covers certain providers and certain doctors and certain hospitals. And so just being able to, you know, take that insurance card and find another willing provider also might not be so simple. And in that instance, if you are paying for insurance that you cannot use, and then the only provider who will treat you or provide the service you need is not in your plan, you know, then you're paying out of pocket, which, you know, for most of us, or many of us, I should say, is a barrier, but particularly for low income people.
Yeah, great. Thank you. Jennifer, Susan, do you want to add anything to that? Thanks, Jamil.
Yeah, I would just say all of that, absolutely. And for some members of our community, for transgender folks, for example, folks have been so invisible for so long that there's a reality that there are plenty of providers who feel they really don't know what the appropriate care would be. So that's just another level of barrier. I mean, it's something that that many people are working on, to have to have our health needs be more visible in medical education and in provision. But if there are institutional policies that are getting in the way of those folks who want to provide the right care and are ready and prepared to do it, it can really leave people without any good, competent options.
And I would also add that people often don't know. There's, this very robust enforcement mechanism and posting notices, but there's nothing in the rule about informing patients about where they can get care, or even informing patients that this provider has an objection. There's nothing requires a Catholic hospital to put up a sign that says, here are the services that we are not going to give you. So patients also struggle to find out where they can get the care that they need.
Thanks, Susan. So Susan, a question for you. There are many providers who do not refuse to provide services. If people know services aren't available, then you told us that a lot of times they can't go somewhere else. But what are the requirements of objecting individuals and institutions to notify the public of their objections?
Well, so it's trying to say very little. The rules do not require it. There's nothing, unfortunately, in the Affordable Care Act that says that the enrollee handbook, for example, has to give this information. The only places in the Medicaid managed care rules, which is new as of 2016, Medicaid managed care organizations do have to inform when they have an objection to covering certain services. We saw this for many years in New York, for example, Fidelis Care, which of course has now been sold, so hopefully that's changing. They have to inform their enrollees in a usable way that there are certain services that they don't cover when the state covers those services, and to tell them how to get them. But that's relatively new, and it's only in Medicaid managed care.
Does anyone want to add anything to that? Okay, Jamil, I have a question for you. Can people be denied care based on who they are? So, for example, can a healthcare provider deny care to a child if their parents are gay?
Sure, I'll kick it off, and then I'm sure Jenny might want to chime in on this as well. So the rule does specifically note the denial around services. So, as I mentioned, abortion, sterilization, and then there's this open question about a range of other services that might be able to deny care. However, I think as we sort of talked about, sort of the rule is very vague in many ways, and there's also can be a difference without a distinction, so to speak, where, if a transgender person is denied medically necessary transition-related services, sure, they might be able to say this service is being denied under the guise of not wanting to perform this service, but that still impacts a group of people and a population, a specific population of people. I don't know if you want to chime in on anything, Jenny.
Yeah, well, I would just say a couple things. I mean, one is that among the profoundly troubling aspects of this rule, as has been said, is that it's all talking using the language of discrimination with respect to healthcare providers that don't want to provide care. And it doesn't talk about the interests of the patients or the providers that themselves are trying to take care of patients. It's really completely silent about the impact. But there are other rules that apply in the setting. 1557, the Affordable Care Act has not been repealed. Section 1557 has not been repealed, and people are bringing claims when there's discriminatory denial of medically appropriate care. Those cases are being litigated. Courts are speaking to it, and there's other relevant rules, Title VII and others, and state law rules. And as Susan said so well, among the problems of the many problems of this rule and the new division is not addressing how these different rules are expected to work together. Well, we can look at it and know that the that the goal transparently is to elevate religious rights and to, to not talk about the other protective rules and laws that are in place. But the problem there is that there already is discrimination that already happens, and plenty of times the patient doesn't know if there are rights, and if so, what those rights are. There's another confusing part of the rule that we should call out here, which is a place that says if there are greater religious rights under state law, then they certainly remain robust, and this isn't to preempt them. Well, what about the non-discrimination rules that are there in state law? By implication, are those supposed to be preempted, or are they still there robustly because they haven't been mentioned one way or the other? I think we're particularly concerned about young people, transgender folks, and folks that already didn't know their rights and didn't know where to go, that this is likely to make it worse. But it doesn't mean that if and when that happens, it's okay and it's justified by the law. It means that we need to do something about it.
Thank you. So the next question is for Susan. Susan, what are the requirements for individuals to inform, if any, to inform their employers of their objections?
Well, the rule is also silent about that. However, outside of the rule, we know that healthcare systems depend on efficient and orderly delivery of services. So the reason that in 8 years there were only 10 complaints filed about this kind of, someone being required to do something to which they had an objection is because healthcare systems want to resolve these problems internally. Many healthcare systems, for example, have a form, and they ask employees, are there any services in which you will not participate, and we'll put you someplace else to the extent that we can. They want to know so that they can make sure that patients are getting what they need, that the OR is being used efficiently, that these rules invite chaos by not including requirements that individuals inform. Let's make that be part of the notice, right? You have to inform your employer, and then they can, to the best extent they can accommodate you. And so that's very, very problematic. That, again, patient care is definitely not the point of these rules.
Thank you. Does anyone want to add to that?
Yeah, well, again, Title VII has had a framework that works not perfectly, but, largely pretty well. It certainly provides good, appropriate accommodation for employees' religious needs. And there's no acknowledgement in this that exists, that there's case law about it, and that whatever this agency is doing doesn't have the authority or the power to supplant what exists under a different statute that's still on the books with a bunch of case law interpretation by the courts. So it sets up confusion, threats, chilling effect, while ignoring the law that was already getting the job done just fine.
Thank you. Jamel, do you want to add?
Yeah, I was just going to add in to pick up off of Jenny's point that, the one thing that Susan touched on earlier, but I think it's worth expounding on, is this broad enforcement authority that they seek to grant under the rule, including, there's a lot of claims that it's aligning with existing civil rights laws, but as Jenny mentioned, it is not, including allowing not only the withholding of funding, either in part or whole, on entities that don't comply with many of these vague requirements under the rule, but also even referring to the Department of Justice for such instances. And again, these very vague definitions of what it means to assist in the performance of, or assist in, or discrimination, doesn't provide any guidance to covered entities about what is prohibited or what is acceptable, or what would be considered a violation, under the rule.
Okay. Okay, we have time for maybe 2 more questions. So Jennifer, a question for you. So you talked about how this rule will impact people in the LGBTQ community, but the rule really seems aimed at refusals around abortion and reproductive health care. So are those issues that you raised kind of tangential and of lesser importance?
Yeah, it's a good question, and I would say no, because first of all, to a patient who needs services, a denial isn't tangential to them at that moment because they need what they need, and that's true for any patient, whatever the need may be. And to have the medical need unmet for an inappropriate assertion of somebody else's religious interests is not appropriate and can be really serious. But there's also, I think, sometimes a mistaken sense that reproductive health care isn't relevant to the LGBT population, and that's not true. I mean, certainly there are plenty of women within the LGBT community that need access to abortion, need contraceptive care. This may be lesbians and bisexual women. Sometimes it's transgender men who need access to abortion care. People have sometimes ideas about who other people are, and they don't really know their life. They don't know their family life. They don't know their sexual life. And so there shouldn't be assumptions of that sort. These are services that are important for all sorts of people. And that is absolutely true for the LGBT community, which again is part of why I give thanks to providers and Planned Parenthood in particular for being so important, providing services, and also that our advocacy frequently is 100% aligned. Our community has a bunch of needs, and not everybody knows what they are.
Great, thank you, Jennifer. Okay, so we're going to wrap up. So the last question I have for all of you, and Jennifer, you kind of touched upon this, but if you want to speak more on it, please do. What can people do to push back against this proposed rule, to push back against refusals that will allow for this type of discrimination? What would you say? Start with Jamil, then Susan, then Jennifer.
Sure. So I think, so as Jenny mentioned, there's an upcoming comment period that ends on March 27th. And we encourage, I think submitting comments can sound like a Herculean effort, but, it can be quite simple of just writing. It could be a personal story. It could be how you think this rule might impact yourself, or how you think this rule might impact a family member, and letting HHS know what your concerns are there. They are required by law to sort of respond in some way so the more comments, the sort of the better, and justify decisions, whether they choose to accept or ignore recommendations offered. And also, we have at Planned Parenthood like I'm sure many other organizations have a action alert that allows people to simply type in your information and send comments that'll go directly to HHS. I put it at the end of my slides, so you feel free to just click on that link. And then there's also, this idea of telling your personal stories, and that can be while on social media. It can be we've been collecting stories to help get sort of uplift, many of the stories we highlighted here about what this rule could actually mean to real people. And please do engage Planned Parenthood Federation on social media. Reply back. We'll be talking about this not only up until the comment deadline, but I'm sure for many months to come.
Great, thanks, Jamil. Susan?
I don't have that much to add. I think that stories and experts, there's a lot of data out there, and sending that information to HHS, really creating a robust record of what this really would mean. I think it would be good for them to hear from healthcare systems about how this will actually disrupt care and undermine quality care. So I think that those are some of the important things. And I think also beyond these comments, sharing what is happening to patients is really important. We know that the Trump administration is going to be very assertive in bringing these cases to court. The Department of Justice filed a lawsuit yesterday, the day before, on behalf of a woman in a nurse in a nursing home who refused to get a flu shot. So we know that they are going to be trying to make points in the court, as are we. Jenny brought a real landmark case in California against a fertility doctor who was providing a fertility clinic, fertility services, and refused to serve a lesbian couple. And the court ruled for the couple that was absolutely impermissible. And so we also need to use the courts to uphold these rights.
Great, thank you. Jennifer?
Yep. So all of that, and I guess I would add, certainly for our community, but I think for many of us, many people, our silence has not helped us over the years. Our invisibility, our silence. Opinion research shows us that there's broad recognition in the American public that healthcare should be about healthcare for patients, and that there may be sort of an automatic respect or deference paid to people's religious beliefs as part of American culture, but it's not unlimited. It doesn't go to the extent that is often asserted in these contexts. The Office of Civil Rights within HHS was set up to look after the civil rights of patients, not the rights of medical workers, employees who don't want to do parts of their job. So there really is something here that's been turned on its head. We have found on a couple of occasions that some of the anti-LGBT policies that this administration has proposed did not happen when there was enough public pushback. Some of what they've done, they appear to think will fly if it's out of public view, if it's too confusing, if it's not generally called out. So our ability to call it out through the comment process and all the other ways that we participate in society could possibly make a difference. I'm not super optimistic. I think there will need to be other ways of pushing back too. But I, again, would encourage all of us to put the word out among all of our networks and communities that we do want to hear when people are having difficulty, because those concrete examples of what is being done in the name of religion will probably be the necessary evidence and information with which the legal arguments will either succeed or not succeed as we're proceeding in the administrative arena and also in the courts. We need to have the concrete examples, because I do feel confident that the American public won't stand for it.
Yeah, thank you. And just to quickly add to that, and everyone kind of talked about the stories. We really do need stories about how these refusals are impacting people. The National Women's Law Center, they did polling on this, and when a lot of Americans hear about religious exemptions, they think, oh, they're not that bad. They don't really understand the full extent to where they allow providers to refuse care and they allow for discrimination. But when people hear about the harm that can be caused by these refusals, then they change their views dramatically. So the more stories, the better. Thank you all our esteemed panelists. Thank you for sharing this really useful and vital information. And thanks everyone for tuning in. Okay, thanks all. Bye.